because people don't read the contracts, they don't know what's in them. And so the things that are in them can be bad. I think, privacy policies are a clear example of this, where people might like their data to be handled in certain ways, but they don't know exactly what's going on, and they don't know what they've agreed to in the terms and conditions. Although, I think actually there are also a lot of cynical consumers who just think, well, they're going to do whatever they want to do anyway, so why bother?
The Rational View is a weekly series hosted by me, Dr. Alan Scott, providing a rational, evidence-based perspective on important societal issues.
Produced by Soapbox Media.
The world needs evidence-based public policy now more than ever. Making the right decisions should not be partisan politics. Please help spread The Rational View by going to patron.podbean.com/The Rational View. Together, we can make a better future.
Hello and welcome to another episode of The Rational View. I'm your host, Dr. Al Scott. We've all seen them, endless terms and conditions followed by a click box. Pages of terms and conditions whenever you sign a contract with a large company for services, loans, or just employment. Often the terms and conditions are illegal or unenforceable, yet you feel you need to sign them just to live, just to get by. Are we now at the mercy of the large entities because we sign up to these onerous terms? Things are getting out of hand. We need some balance. We need a rational view to get to the bottom of this problem. Daniel Wilf-Townsend is an associate professor of law at Georgetown Law. His research focuses on the regulation of markets and technology, and in particular on the processes that legal institutions use to move the law from being words on paper to having actual consequences in everyday life. He teaches and writes on artificial intelligence, consumer protection, and civil litigation, and his work has appeared in the Harvard Law Review, Virginia Law Review, Yale Law Journal Forum, Stanford Law Review Online, and other legal and general interest publications. A graduate of Yale Law School before entering academia, Professor Wilf-Townsend was a litigator at Gupta Wessler PLLC, a boutique law firm focused on public interest litigation in appellate courts and the Supreme Court. Professor Wilf-Townsend, welcome to The Rational View.
Thank you. It's great to be here.
You have a very interesting bio. Could you tell me a little bit about why you decided to leave litigating and become a researcher?
Sure. Yeah. Great question. So taking me back a few years. Well, basically, I had always thought possibly in law school that I would want to be headed in an academic direction. I just think the questions that you can get at when you're an academic are really interesting. But it's a hard job market. And so I thought, I also like arguing and debating and being a practicing lawyer. And so I thought I would try being a litigator first. I got basically the best lawyer job I could imagine having at this firm in Washington, D.C. that's focused on appellate and Supreme Court work in the public interest. And it's great people. It's a small firm. They do really interesting work and they do really kind of meaningful work. And so that seemed like the dream. But I always felt like, as a lawyer, your job is not to seek the truth exactly, right? Your job is to represent your client's interests.
Right.
And I always felt like there was part of me that just wanted to be able to approach a question with the open mind of, what do I think is the best answer here? And, as a lawyer, that's not exactly your job. And so I missed having that part of me being active. And so I thought, if this is like the best job as a litigator I can imagine, and I'm still feeling like that gap, academia was my way of giving myself more space to kind of take a step back and be able to think through issues without feeling like I had to answer in a way that was conducive to any particular party's interests.
Yeah, we actually happen to share an interest in artificial intelligence.
Oh yeah.
How does AI intersect with law in your research?
Oh man, well, so it's a burgeoning field for sure, right? So there's a few different strands that I work on. So I focus on questions of law and scale. So sort of situations where legal institutions are dealing with harms that exist at scale, or types of lawsuits that have high volume repeat filers or repeat parties filing many of the same types of lawsuits.
Okay.
And in that world, I think AI comes up in a variety of ways. So first of all, AI can be, as an entity that is regulated, AI can generate harms or legal claims at high volumes. If you have this is sort of taking it, maybe a few years in the future, because this is not something that's happened that much yet. But if you have, a diagnostic algorithm replacing a physician, one physician can only make so many diagnoses in a day, but a diagnostic algorithm can do much, much, much more. And so you have that kind of algorithm violating the law in some way, not being up to a standard of care. It's possible that you're going to deal with situations where the numbers are quite high, and the law is going to need to be able to handle many, many, many people with claims against that algorithmic system. I mean, one way that's actually concrete that you can see in the real world right now is with, I don't know if you've seen any of this litigation around algorithmic pricing. So there are a couple different cases, but so there's a tool that landlords use to price their apartments. And many different landlords in the same city can use that same tool. And there are allegations that this basically amounts to price fixing, because the algorithm kind of takes information from all the landlords and uses it to come up with its recommendations.
Get them the best prices. Exactly. I have heard of that. Yeah.
So it's in some ways, the argument is that it looks kind of like a cabal, like the landlords are working together through this coordinating mechanism of the algorithm to maintain artificially high prices together.
Sneaky.
And so, yeah, that's another example of kind of AI operating at scale in a way that the law is going to have to deal with. In the past, certainly before computers, landlords would have to make pricing decisions individually. Even after computers, landlords would probably make decisions about their own properties, maybe in an Excel spreadsheet or something. But you wouldn't have one software tool making sort of real-time updating over tens of thousands of units all in the same retail market. That's kind of an AI is empowering that kind of behavior in a way that didn't exist before. So that's one way that there can be operations at scale that the law needs to be able to regulate. Another way that AI and the law intersect along the dimensions of questions of scale is through lawyers using AI as a tool in their litigation management. So using it to onboard plaintiffs and draft complaints or draft briefs or draft other pleadings to lower their costs. And this is particularly relevant in kinds of cases where you have many plaintiffs with similar kinds of claims going against the same defendant. And so you're just kind of getting their biographical details. They might write you a few paragraphs about their story. They might upload their medical documents to a server that you've got. And then you have an AI tool read through all of that and draft a complaint and bring it into court. So that's that. There are companies that are marketing that kind of software right now. It raises a lot of ethical issues and sort of a lot of institutional concerns about how the courts are going to manage that. So yeah, there's just I could keep talking about this for a long time.
You teach a course on it, I guess.
Yeah, right, exactly. Yeah.
Yeah, that's very interesting. Interesting how it's going to be changing quite a bit, and the volume of cases. I think we're going to have to go to AI judges to handle them.
That's one proposition. It has its own downsides too, of course.
Yeah, well, I mean, you end up with a market of everything is handled by AI. The market right now, buying and selling decisions, if that's handled by AI, does that skew everything? I mean, that's quite an interesting future that we'd have to think about. I mean, it's already like that in investment markets, I guess. Right,
and you see this. You see this kind of pattern emerging in a bunch of different contexts where you have some sort of exchange between two people or two sets of people, and if one side starts using AI, that creates immense pressure on the other side to start using AI as well. But then if you have both sides using AI, does that remove some of the value in the exchange, or does it warp people's incentives in various ways? So you see this, students using AI to write essays, and teachers using AI to try to detect who is writing essays, even if those tools are very unreliable. Or, I've even seen some people joke about, students using AI to write the essays and professors using AI to grade the essays. And so no one has to do any work. They can just all go about their merry way. And that obviously seems like a problem too. Or you have job applicants using AI to write applications.
That are reviewed by AI.
Right, exactly. But then, people can write 100, 200, 300 job applications in a short span of time. And then the companies that receive the applications are overwhelmed. So then they have to use AI. And so it's this kind of arms race or spiral. And I feel like we haven't figured out what to do about that yet. And I think maybe the law will be a tool that's useful there. Maybe not. The law can also create problems in those kinds of exchanges as well. But I think that's like a pretty interesting set of issues that people are facing right now.
It's definitely something that needs to be talked about sooner rather than later, I think. Yeah. So, I mean, the reason that I invited you on the show is that I was, getting depressed about terms and conditions, and I went searching on the internet, and I found a paper that you wrote recently called "Deterring Unenforceable Terms" in the Virginia Law Review. And the abstract starts as follows. Contract law doesn't work the way most people, that is, non-lawyers, think it works. People think that if they agree to a contract, they're bound by its terms, no matter if those terms are unfair or legally unenforceable. But that's not correct. Although there is a default presumption that the law will enforce terms that parties agree to, courts can and do decline to enforce terms when they are contrary to statute, regulation, or common law. So I think this is a very important statement, and as you correctly say in your paper, there seems to be no drawback to a company writing threatening clauses into contracts and forcing them onto employees and customers. Why don't courts treat this as fraud or blackmail?
Right, it's a great question. So there's a few different reasons there, but one is that you may be familiar with the maxim, ignorance of the law is no excuse. And I think we all think of that as a pretty reasonable policy when it comes to someone claiming, that they shouldn't be held to the law's obligations because they, didn't know, I didn't know murder was illegal, or something like that.
Sure.
But it turns out that kind of reasoning rears its head in areas that I think sometimes make less sense, which is that there is a doctrine that courts use that people are presumed to know the law. And so people are presumed not to be deceived by false statements of the law, which is, I think, a much more ambitious and possibly problematic kind of interpretation of that, statement that we assume people know the law. So the company puts in its contract, we are not liable for any injuries that you suffer. That statement can literally be false, right? It can be the case that courts will hold the company liable for injuries that a person suffers on their premises. But a court will not penalize them for the falseness of the statement. At least that's not the normal approach, because instead they say, look, we assume that the people reading the contract will know that that's a false statement, and they just won't. The courts will just decline to enforce the statement because of its falseness.
So they're saying it's unethical, but you should know better.
Well, they
listen to us.
don't even really say that it's unethical. So I think them saying that it's unethical would be a step in the right direction. But instead, the main way that courts approach this problem is through the doctrine of unenforceability. So they just say, our role here as courts is to enforce contracts. We only enforce terms that are consistent with the law. If a term is inconsistent with the law, then we won't enforce it. And that's the penalty that we put on the company, is to not enforce their contract terms. And so therefore they don't get the benefit of the bargain in the term. But that's, I think, obviously a little bit silly, as you mentioned that I put in the paper. There's really not a lot of reason for companies not to put these unenforceable terms in. I think under the old school classical understanding of contracts are these bargained for agreements. They're negotiated. So the idea was, well, if a company puts in a liability waiver, the other side, the consumer, doesn't like that. So there must be some other thing that the consumer is getting in exchange for that, like a lower price or something. But we know that's not true. Consumers don't read these contracts. So the price term is not lower because of the liability waiver. Consumers aren't aware of the liability waiver when they're deciding to buy the product at that price. But that's where the idea that not enforcing a penalty or not enforcing a term is a penalty, that's where it comes from. Because the idea is, well, a drafter of a contract would have to give something up to get such a beneficial term. And so if you don't enforce the term, they've given something up for nothing. And that's the kind of penalty involved. I just don't think that logic really stands up to scrutiny, even though it's intelligible, it's coherent. I just don't really think that it actually makes sense given the way that contracts work in most consumer and employment contexts.
Yeah, I mean, you get these 10-page fine print legalese, terms and conditions that are just inscrutable to the average person on, say you're getting a loan from the bank or something, or you're taking an employment contract. I mean, it's just a team of lawyers have written this thing to basically abscond themselves of any sort of reasonable back and forth, right? I mean, that's not what this is meant for, is what you're saying.
Right. And there's a few problems with that. I think, one is that because people don't read the contracts, they don't know what's in them. And so the things that are in them can be bad. I think, privacy policies are a clear example of this, where people might like their data to be handled in certain ways, but they don't know exactly what's going on, and they don't know what they've agreed to in the terms and conditions. Although, I think actually there are also a lot of cynical consumers who just think, well, they're going to do whatever they want to do anyway, so why bother reading? There's a rationality to that. But so that's one problem. When you don't read contracts, you don't know what's in them. But then the second problem, the one that this article is about, is actually kind of about if you do read the contracts, then you can get burned that way too. And this usually happens after the initial transaction. So like, if you're a tenant and you sign a lease, you might not look that closely at all of the provisions in the lease. But then let's say you want to break the lease, or you have a dispute with your landlord. Then you go back and look at the relevant provision, or the landlord might invoke the relevant provision. They might say, hey, look, you agreed to this. And looking at the term in that lease, you might think, wow, I agreed to this. I have to do what it says. And so maybe it says, if you break the lease, you owe the rest of the rent on the contract up front. Or maybe it says, the landlord is not responsible for maintaining good livable conditions, or something like that. And either of those lease clauses, either of those provisions might be totally unenforceable. No court would enforce those in various jurisdictions. But you don't know that. And it says it right there, and you agreed to it. And so you feel like you maybe need to give your landlord the money, or you're willing to settle if the landlord says, look, it says you owe me all the rest of the rent. Why don't you just give me $1,000 and we'll call it even? That might be $1,000 that you don't actually owe them, but you don't know that. So this is the problem of reading the terms, in addition to the problem of not reading the terms.
Sure. Yeah, your abstract, also says the problems of unenforceable terms arise from the burden of determining whether a contractual provision is enforceable. The current law makes little effort to allocate or mitigate that burden. But in a common scenario where a sophisticated actor drafts mass contracts from many non-sophisticated counterparties, which is, the thing that most people are upset about is these huge terms and conditions for everything they have to do. The drafter is much better positioned to determine the contract's enforceability. The law should therefore penalize such drafters for including clearly unenforceable terms in their contracts. So what do you propose? How can we fix this?
Yeah. So the paper, I think there are a few different routes we could go about doing this. One would be through the kind of legal ethics route. You mentioned the ethics earlier. It could be the case that the bar in the United States, the lawyers in the United States are kind of a guild. We are a supposedly self-regulating set of people, and we have a set of professional obligations and ethical requirements. One possibility would be to say it is a violation of our ethical obligations as lawyers to draft contracts with terms that we should reasonably know are unenforceable. That, would at least be, I think, a step in the right direction. It could come with some penalties. You could be sanctioned. I mean, disbarment potentially as well. That's pretty extreme and also not that common. So that's sort of, I feel like that is a relatively low ask of ethical enforcers. I think that the ethical arguments here are pretty strong.
Is that a term in any bar associations?
So no, it is not currently. There have been a couple efforts, one in DC, one in California, to make it happen, but so far nothing has gone through. There was also an original effort back. I'm going to get the number of years wrong, but it's sort of in the mid-late 20th century, an effort to make this part of professional responsibility and legal ethics. But each time so far, it's been defeated. Lawyers don't like adding to their own liability, and drafting contracts is something lawyers do a lot. So
self-interest.
Right, exactly. So lawyers often are squeamish about putting these kind of requirements.
And if you don't have unenforceable terms, then you're going to have less court cases.
Right. The route that I think is maybe more I think it would probably be more effective, and it may be more likely to happen in part because you don't need the kind of consensus of the professional bodies, would be to use consumer protection law to try to go after these worst terms. So you could do this in a few ways. And one is you could pass legislation. You could have legislation that specifically says something like, it's a violation of this statute to draft a law in a mass, or to draft a contract in a mass contracting context with terms that or should reasonably know are unenforceable in a jurisdiction in which you intend the contract to be used.
Mm-hmm.
And there's a lot of legalese in there. I'm happy to unpack any of those phrases, but I think the idea is you want to have something that doesn't just say that is going to be unenforceable, because it's hard to prove what someone did or didn't know. You want to have it, something that says, like, what should you reasonably know? If you were a lawyer engaged in some minimal level of diligence, you took a look at what is allowed and what is not in various jurisdictions that you're trying to do business in. And if you put in that diligence, you would have seen that you can't have this type of clause. Well, then you shouldn't have that type of clause in the contract. So that would be a law that, a state legislature could pass anytime.
But what if your company operates in multiple jurisdictions and you want to just draft something that has the strongest possible terms in it? Then you just put the worst ones in for everyone, and hope that they reinterpret. Put in a clause that says reinterpret it to be the worst possible contract for the other person.
Sure. Yeah. And I think that there is. I think there's sort of two thoughts that come to mind. I mean, one is that, if you're a jurisdiction that bans liability waivers, it's like not that compelling of an argument to say, like, oh, well, we also do business somewhere where liability waivers are allowed, and that means we need to be able to ban liability waivers in your jurisdiction too. We have different rules for different business operations in the 50 states all the time, I think that's part of the idea, is that if a company is going to get to benefit from doing business in your state, it's got to follow your laws. But there is a real concern, sort of in what you're saying too, that it can be hard for companies to keep track of all the laws in all the different places. And that is a burden. So I think it's important to be honest about the fact that, like, it would be a burden on companies drafting contracts to say, you can't have unlawful terms in your contract. It's another box they have to check. It's another sort of diligence test they have to do. And so there is a real question about whether the cost is worth it. And I think one of the motivations for this paper is just that in recent years, there's just been a lot of evidence about how widespread these terms are.
Mm-hmm.
Also, a lot of evidence that they really do have an effect on employees' behavior and on consumers' behavior. So if you're an employee who has a non-compete clause in your contract, there's evidence out there that affects whether you're going to look for another job or not, even if that clause is completely powerless as a legal matter.
Well, yeah, you would often see a non-compete clause with, say, you can't work for anyone else in the field for 2 years or 3 years or whatever this is. And if you take us to court, you will pay all the fees, right? So
right.
Obviously an employee would be scared to take it even to court to find out what their rights are.
Right, exactly, and it's this, the same reason that I feel like the burden should be on the drafters is what is making the employees hesitant in this situation too, which is they don't have legal expertise. The other side has all the legal expertise, and so the employee thinks, well, they're the ones who know all this stuff. I'm going to lose if I go up against them, and it feels to me exploitative to allow people to use that kind of legal knowledge in that way, when that legal knowledge should be the very thing that means that they're the ones who are well situated to know that these kind of clauses aren't legally enforceable in particular contexts.
I mean, is there room for a class action here? I mean, these companies are benefiting from things they know to be illegal, extorting extra stuff from people by writing these in. This seems to be a clear-cut case of fraud or blackmail.
Yeah, so I mean, I think that fraud and blackmail have their own particularly high standards of proof, and it can be quite difficult to make a successful class action around. But there's sort of I think the way that I would probably approach it if I were back in the shoes of a plaintiff's lawyer like I was years ago, would be through consumer protection statutes. So there are statutes that are often called UDAP statutes, UDAP, unfair, deceptive acts and practices. And they're these kind of broad catch-all laws saying companies shouldn't do unfair or deceptive things. And it is certainly the case that, at least I think there's a very strong argument that some of these unenforceable terms are deceptive. And maybe that they're unfair as well. They mislead people. Like the statement I said earlier, we are not liable for any injuries caused on our premises. That can be false. That can be deceptive. And they're designed to benefit from people's deception. The thing that is difficult. So for a class action, for most of these statutes in most jurisdictions, you're going to need to prove that the plaintiffs were harmed in some way by these terms. So it's going to be hard to prove that you were harmed just by the existence of the term in a contract that you signed, especially because we know most people don't read the terms in most contracts that they signed. So instead, you need to find a way of getting to the people who actually were hurt by this and having them be the plaintiffs. And that's hard. So, it can't be every person who signed a lease with this rental company. Instead, it's going to be more like everyone who the landlord said, look, you broke your lease, you owe me this money, even if they don't. And that's, just by sort of the nature of how life works and how commerce works, it's going to be hard to find a group of those people. It's not, the company probably won't have like records that identify people by that category. It's not something that people are often going to be, bragging about online. It's not that legible.
I got screwed by so-and-so.
right, yeah. So that's one of the reasons to try and have the enforcement be kind of upstream, where you just try to get these provisions to not exist in the first place in the contracts, rather than relying on downstream private enforcement by like class actions. I do think that maybe a regulator would be well situated here, where the regulator can just say, look, it's a per se violation to have that kind of clause in your contract. And we are the state, we don't need to prove that we were harmed. That's not a requirement that usually exists for when the government is bringing the enforcement action. And so they can just say, get rid of these clauses, because they know it's quite hard for the people who are actually harmed to identify each other, to even be aware that there is a legal cause of action here. And so probably public enforcement is going to be the better way to go here. But that's just a hunch. I'd be happy to see any enforcement.
Yeah, that's true. Is there anything we can do about like just extremely long terms and conditions for like a $2 video game? It just seems completely out of proportion, the amount of legalese one has to weed through to do anything in society. It seems out of hand.
Yeah, it's a great question, because I think we all know that nobody reads them, because the cost benefit analysis is just ridiculous. Why would you spend 12 hours reading the contract of something that you will be doing for 3 hours?
Researching the law and
right.
Is this true? Is this false?
Right. I'm a consumer protection scholar. I teach at a law school, and I don't read those contracts. And I think contracts professors don't read them either, from what I can understand. Um, it's tough because banning contracts seems, you don't want to just ban contracts in general. That seems tricky.
Right.
A lot of downside there. But you also don't want to enable people to get the benefit of making contracts unreadable. There have been various attempts. You could try to say, there are a lot of proposals out there, right? You could try to say the most salient terms have to be at the top of the contract in a box with big letters, in capital letters or something. And salience can be determined either by like a list, you have to have like the price and any waivers and whatever. Or some people have proposed you could actually have like a focus group, and the focus group of consumers gets to like say what are the most salient things, and those things have to go in a box. There are proposals like that to try to highlight and put front and center the most important terms measured in different ways. One proposal by a law professor, Dave Hoffman at Penn, is to actually just make all those long contracts presumptively unenforceable overall, just not binding. Just say, okay, you can write stuff down, but we're going to start with a presumption in a lot of these small scale consumer contexts that the writing just doesn't really bind. And instead we just, use everyday background principles of law and common law to what's going on. And his proposal is more nuanced and complicated than that, but that's one possibility, to just say, all right, these contracts don't mean anything anymore, unless certain other boxes are checked or certain other conditions are present.
Or maybe there's a body that reviews them to blue check mark them.
Yeah,
this one is enforceable, this one isn't.
Right, and this is this goes beyond my area of expertise, because I'm not a comparativist, but my understanding is that in certain other countries, there is more of like a whitelist, gray list, blacklist kind of approach to contract terms in various consumer contexts, where there's kind of like a ready-made list of okay terms that the government has approved. And if your contract just includes those terms, then you're good. Or another way of doing it is requiring you to send your contract to a regulator before you start using it and have the regulator pre-approve the contract. So that's another way of doing that. And some contracts in the US are like that too. I mean, some heavily regulated industries like insurance have what is functionally a high level of contract language approval by the regulator. So there are a lot of different potential regimes out there.
Interesting. I mean, this is great. This is wonderful. I think, we've all been flummoxed by long terms and conditions. Have you received any other feedback on your proposals for deterring unenforceable terms?
Yeah, I mean, I think a lot of people are sympathetic to the problem. I think some people want it to go even farther, to say like, it's not just mass-produced contracts with a sophisticated drafter, but just all contracts. You just shouldn't be allowed to have it in there, or there should be big fines and penalties, and people should lose their bar license and that sort of thing.
Yeah.
Other people, I think, are more skeptical that there is a problem, just because of what we talked about earlier. The fact that consumers don't read contracts means that maybe these terms are just like a tree falling in the woods. So, which I think there's something there too. I think it's hard to know. This is one of those things where it's hard to know the scale of the problem, because so much of it happens in these kind of isolated interactions, like I said earlier, where no one's writing up a report about it. But I'm still concerned enough. The evidence about employee behavior and non-competes and consumer beliefs after reading these contracts is enough to make me concerned.
Yeah, no, I agree. So if we are on side with you, and yes, we would love to get these things fixed, what should people be doing? How can we support getting these things implemented? What's the next step?
Yeah, I mean, that's a great question. Law professors, I think, are notoriously bad at politics. So I don't want to pretend like I know, the right mechanism for law reform here. But, there are a few options, right? So who makes laws? Well, legislators make laws, regulators make laws, courts make laws, and those are each different pathways to making or reforming these kinds of laws. So if you're a lawyer, you could work with the bar about the ethical issues here. you could potentially, if you're a plaintiff's lawyer or someone who does consumer protection, you could try to bring test cases under these broad statutes, so these broad unfair and deceptive acts and practices statutes, try to bring test cases about unenforceable terms to try to set a precedent. That's one route. You could try to get legislative activity going. If you're a lawyer or if you're just a non-lawyer, you can try to use the good old-fashioned democratic method to get reform happening through legislation. One thing that I think is happening right now, which I guess suggests that this is one of the most plausible ways for reform to go through, is there is essentially sector-specific reform happening at the level of individual agencies. So the Federal Trade Commission, the FTC, has been working on a ban for non-competes in employment contracts, or the CFPB has been building a database of unenforceable terms in consumer financial agreements. And none of these is going to be as broad or as sweeping as a general prohibition on unenforceable terms, but those sectors, employment, consumer finance, those are quite big and broad sectors. And if you start working on the problem within sectors at that level, it's probably doable to get more done. Now, of course, with the current presidential administration, all those agency activities are, I think, their future is in doubt. But the fact that the agencies were able to take those problems up, I think, suggests that, maybe they'll still be able to work on them now, or maybe they'll be able to resume them in the future.
That's quite a list. I'd certainly think that, usually it's follow the money that gets things done. And the idea that you could go after some of these things through deceptive acts and practices and make them costly mistakes is where you're going to see things change. Now, I'm not, much of a politician either, but I don't know any better way to motivate change than to make it cost money.
Yeah, that's certainly right. And I think that, again, the problem is just on the sort of mechanics on the ground of under those consumer statutes being able to prove harm at a level that's broad enough to have the damages matter. But if someone can think of an example of a case where it works out, I think that could be a good way to go. And
I suppose the penalty that's enforced in such cases is proportional to the harm done, right?
Typically, yeah. I mean, so there are also what are called statutory damages, which is where instead of having to prove a specific level, a specific dollar amount of harm that was done to you, you can just say the statute says it's between $100 and $2,000 per violation, and then you argue for why it should be set somewhere within that range. And those statutes are designed for contexts where it is hard to measure exactly how much damages occurred, but there's still some sense that for deterrent purposes, you need to have real money on the table. So that's another way that damages are portioned out too.
Well, that's very interesting, and I really appreciate the work you're doing in trying to get this, bring the focus onto this issue, because it's one of those things where it's mildly annoying most of the time, but we don't need to have mild annoyances. We have enough major annoyances. We need to plug away at all of these things somehow.
Yeah, that's one of the things I love about this paper topic and about working in consumer protection in general, is that we're all consumers, and this stuff happens to us every single day. And that means that first of all, it means it's relatable. It's easy to talk to people about it. But second of all, it seems like it means there's room for improvements. They can be broad. When you're dealing with problems that affect sort of people throughout the country, throughout the world, legal fixes can make life a lot better.
Indeed. Well, thank you for your time today, Professor Wilf-Townsend. It's been a pleasure speaking to you on this issue and learning a bit about the legal profession and how laws are interpreted and how they are bent to make money. So thank you for your time.
Of course. Thank you for having me. It was a pleasure to be here.
If you'd like to follow up with more in-depth discussions, please come find us on Facebook at The Rational View and join our discussion group. If you like what you're hearing, please consider visiting my Patreon page at patron.podbean.com/therationalview. Thanks for listening.